So former President Jacob Zuma will today lay charges against State Prosecutor Billy Downer for allegedly leaking confidential medical records to the media. This comes just under a week before Judge Piet Koen rules on Zuma's special plea at the Pietermaritzburg High Court for Downer's recusal. So the question is, how will this criminal charge potentially impact the case? Legal analyst Mpumelelo Zikalala joins us now for more on this story. Mpumelelo, thanks very much indeed for your time. Great to have you on the program. Never a dull moment insofar as the court proceedings around the former president is concerned. So explain to us how the decision, which is now still pending around Billy Downer's recusal, and this latest criminal charge that he's laying against the state prosecutor, how do those affect each other?
Let's remember that while we are waiting for a decision, if it goes or it supports the state, then the prosecution will continue. Mm-hmm. And the basis would that be, if you want to still challenge the conduct on the manner in which the prosecution behaved in this manner, rather use Section 35 instead of using Section 106 as we are doing now. Now, that lays a fertile ground in terms of saying, when we deal with the Section 35 application, in terms of saying, I've opened a case against a person who is dealing with this matter currently, has a criminal case pending against him, mm-hmm. because they have contravened Section 41 of the NPA Act. In addition to that, I've also complained internally in terms of his bosses, and I've said they must look into the manner in which he conducted himself. Mm-hmm. And do you really want to have a prosecutor who's going to have a cloud over his head prosecuting my matter? If at the end of the day, those particular two operations ends up detailing that really Advocate Billy Downer is guilty, then it does cast a doubt as to whether did the former president receive a fair trial in terms of Section 35, and that would be a technicality or a technical discharge in terms of the criminal matter. So they are basically laying a fertile ground for the Section 35 application. They are laying a fertile ground of saying we want to discredit as much as we can the prosecution in this case by tainting or showing that the prosecutor in this manner did not behave in a manner in which it ought to behave as per the NPA Act.
Yeah. So let me just try to understand in layman's terms what you're saying. So the existing decision that we're now waiting for from Judge Piet Koen, might he delay that decision pending the outcome of investigations into the current issue that the former president is laying charges against Billy Downer for today, insofar as disclosing his medical files is concerned? So will the High Court potentially say, we've got this outstanding issue, we're going to wait until it's resolved before we pronounce on the special plea that the former president has lodged?
No, the court can't. Let's remember. Okay. When you come to court, you have two blank pages in which they are filled in by the two opposing parties. So as a presiding officer, so in this case, Judge Koen is only dealing with the information that has already been provided to him. Okay. Anything that happens after those submissions have been made, he can't consider those facts into his decision-making process. So when he comes next week, he's going to decide the matter based on the affidavits that were filed earlier, based on the legal submissions that were filed earlier. Whatever that has happened after cannot be considered by him, because by that particular point in time, the adjudication process has taken place and a decision has been taken. But it is going to matter moving forward as to how this particular matter is going to be conducted.
So let's say, for argument's sake, the special plea is dismissed by Judge Piet Koen. The criminal charge that will be laid against Downer today, insofar as allegedly disclosing private medical information from the former president to a journalist, if the matter goes to trial insofar as the arms deal corruption case is concerned, this certainly will be an outstanding matter, surely, insofar as the criminal charge against Downer is concerned.
Definitely it will be. And it's going to bolster the case of the former president in terms of saying, my rights in terms of Section 35 has been infringed. I want to support and provide external evidence of the infringement of my rights by providing the results of the internal process of complaint that I filed to the president, and also the external one in terms of the criminal charges against this very same prosecutor who's prosecuting me today. So I've been trying to prove all this time that he's not doing this particular prosecution because he wants to be a perfect example and he wants to execute his duties as a prosecutor. He has a vested interest in this matter, And I'm not simply saying that with no basis. I have these two applications or these two processes that I have compiled with. They've provided me with a decision, and in fact, he's currently being prosecuted at the moment, or is currently being investigated at the moment.
Mm-hmm.
So it does cast a dark cloud, in terms of the compliance of the state, in terms of protecting the rights of the former president, as per Section 35 of the Constitution.
Right. So let's say after the charges have been laid, how long will it then take for the NPA to decide whether it will prosecute?
I think that's pretty dependent on the information that they will have. But in this one, I think it's
because the NPA, sorry, Mpumelelo, the NPA have said that it's in a situation where it can disclose information for those purposes, for the purposes of relaying information about a case to the media and to the public.
But if you look at the NPA Act, especially Section 41, it simply says, unless you are disclosing that particular information by virtue of your duty.
Yes.
Now, let's zoom in on that. You are a prosecutor inside the court, and you are dealing with information, that's relaying information that you've got during an investigation, so executing your duties in that particular aspect. The second part of it is that if you have been forced by a court of law or, for example, other legislative processes, in this case, PIA, if there's a PIA application that has been submitted, and you ought to comply with it, which is why an NPA institution would have a spokesperson, a person who is designed to talk with the media, to liaise with the media, so that the media does not liaise directly with the prosecution.
Right.
Now, in this case, what Advocate Piet Koen would have to say or submit is to say, why did you bypass the spokesperson that have been employed by the NPA with the specific task of providing information to the media and provided information?
Right.
But most importantly, what caused you to be so frustrated that you provide information that you've obtained during the course and scope of your employment as a prosecutor to a third party, to such an extent that you even depose to an affidavit in civil proceedings outside the confines of your employment? So what prompted you to do that? Did you have authority to do that? Do you think it's right that a person within your position would obtain information by virtue of their duties and feel it important or deem it important that it is disclosed to third parties? Yeah. If you can do that, how many other people can do it? And is it in line with the NPA Act that you sought to abide by when you were employed as a prosecutor? Yeah,
because Zuma's lawyer, that's Advocate Dali Mpofu, his assertion is that the information was disclosed before that affidavit actually became part of court documents.
So on that one, he's definitely trying to prove that there is a long-standing relationship between Advocate Piet Koen and the media or third parties, in which information has been disclosed to without prior written consent or outside the confines of the sections provided by the NPA Act. If indeed he has done that, that is in direct contravention of Section 41 of the NPA Act, and the normal flow of offences and penalties must then apply. But before that happens, he must be given an opportunity to respond and try and substantiate or justify why did he engage in that particular fashion in that action, so that at the end of the day he was able to disclose that information.
I mean, I think safe to say if there is a decision from the NPA not to prosecute in this matter, it is something that the former president will take up in private prosecution.
Definitely. I think there are people who would say the minute we say we're going to prosecute, then I'm willing to step in and take it forward. However, to remedy this whole situation, it is very clear. If the NPA would say, we are now removing Advocate Piet Koen as the lead prosecutor in this matter, we are going to include someone else, then all the other applications which have been a bone of contention in terms of this matter would fall away. Because then the state would say, we have a new person who's there, an independent person who's not tainted or not followed by their cloud, and is definitely going to be able to prosecute. It doesn't mean that Advocate Piet Koen cannot be a part of the particular matter, because he can still provide the institutional memory. He can still provide advisory services whenever he's called to do so. It's just that he won't be the lead person who will stand up in court and extract the various evidence in which is required to prove that the former president is guilty beyond reasonable doubt.
So in your mind, it won't impact insofar as the procedures around the case is concerned. Losing someone in that position who has so much institutional knowledge of the case?
Not really, because the only thing that we are losing is that that particular person will stand up and do the talking. So in terms of the information, in terms of the methodology of extracting the information, and making sure that you are able to connect the dots when it comes to the evidence, so that at the end of the day you're able to get a conviction, if there is one, then I don't see any impediments that can take place. Which is another question that we always ask ourselves as to why is there such a resistance in terms of removing a person who is prima facie tainted in a manner? Because unless maybe at a later stage it would come, there's nothing that justifies a prosecutor disclosing information to third parties. There's nothing that justifies a prosecutor deposing to an affidavit of information that he got within the confines of his employment. It can't be allowed. There are ways and procedures of protecting prosecutors who feel had done. There are ways and procedures of making sure that information, if you feel that your bosses are treating you badly, there are ways and procedures in which you are allowed to protect it. But to engage and use other civil societies, to engage and use other third parties.
I mean, is it proven that they did that?
But you have an affidavit in which it deposed to in a private matter. I think it was a Democratic Alliance matter. Now the question is, who gave you that authority to depose to that affidavit? Let's remember, had you not been employed by the NPA, had it not been a public prosecutor, you wouldn't have obtained that information anyway.
Right.
So it is obtained during the course and scope of your employment. And the minute you say I'm employed by the NPA Act and the NPA Code of Conduct applies to you, and it must be abided to at all times.
Yeah, absolutely. Mpumelelo Zikalala, as always, thanks very much indeed. Legal analyst joining us there. As the former president will today open a case against state prosecutor Billy Downer, he says, for leaking confidential medical information to the media. Just some context for you once again. That special plea for Downer's recusal from the former president's corruption trial, that's to be decided next week, Tuesday.